And you are John Marty Ryan
Yes, Your Honor.
in cause number 25 CR 383. You're here with Mr. Adams, your attorney and the state's attorney. Does the defendant know the formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
Looking, where is he on this?
You first.
Number one. All right, in summary, Mr. Ryan, this indictment you're probably intimately familiar with. It was handed up about a year ago now. And it states that on or about February 22nd, 2025 in Jefferson County, Texas, you committed the state jail felony of criminal mischief. It says intentionally and knowingly damaging or destroying tangible property, lamps, computers, trash cans, by striking and smashing those items. And that was done without the effective consent of the owner of the property. So it caused damages of $2,500 or more, but less than $30,000 to the owner. That constitutes a state jail felony. Do you understand what you are charged with here?
Yes, sir.
If convicted of a state jail felony, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, placed on deferred or unadjudicated probation up to 5 years in length. There is no fine, but you're going to be required to pay the restitution back. That's how you fix a mistake like this. Quicker you do that, the quicker your probation is dismissed, all things being the same. If you fail on probation, your probation could be revoked and you could be sentenced up to 2 years in the state jail. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty?
I plead
Sir,
Your Honor.
are you pleading guilty voluntarily? That is on your own free will
Yes, sir.
and because you are guilty? You need to just answer. Is that true?
Yes, sir.
I'm going to show you. Mark the state's exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney. Are the contents true and correct?
Yes, sir.
State's exhibit 1 is tendered into evidence.
No objection.
Without objection, it's submitted. Other things. You are pleading guilty voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea. The state's exhibit 1 admitted here to find you guilty beyond a reasonable doubt. You were totally satisfied with the representation provided by your lawyer. You're giving up your rights to a jury trial and the rights of the appearance, confrontation, and cross-examination of witnesses. All of this is true, so help you God. State's exhibit 1, part of the record, without objection.
No objection.
Restitution is the issue. It looks like here. How much is that?
Judge, I received an estimate of about $5,000, but I did get with probation and Mr. Adams to let them know that probation and myself will work on getting
Okay,
the exact amount.
restitution is to be ordered, and it sounds like it's in the general range of $5,000, but we're going to get more of a specific amount from the complainant victim, but restitution will be ordered to this person, sir. And the quicker you pay that back, the quicker you'll be released on probation. All things being good.
Yes, sir.
We follow those terms and conditions of probation, and there's a lot of them, but most of them are the terms and conditions of probation that all of us in this room have to follow.
Yes.
Just don't commit crimes, respect others, live honestly, give each person respect. That's generally what this is all about. If you fail, your probation can be revoked and you could be sentenced up to 2 years in the state jail. Pay these people back. If you can do it quickly, then I reward people almost daily for taking care of their business and they get the case disposed of early. And in this case, we've got you on deferred or unadjudicated probation, which means you haven't been found guilty yet.
Yes, sir.
Don't make a mistake. Fix this. At the end, it is dismissed. So you don't have a conviction of this. All right. See the probation office. Good luck. That's all. Thank you.
Thank you, Your Honor.
Yes,
Thank you very much.
Yes. Mr. Okay.
Was that 5 years, Judge? I didn't.
5 years.
Okay. That'll be good.
Got Jessica Wilson and Jessica Wilson here.
That's mine, Judge.
Oh, what do you have?
Franklin.
Mr. Franklin, Judge.
What are we doing on Franklin?
I'm gonna put it on the trial docket, Judge, but,
Do you do anything?
She'd like to come out from.
One trick pony.
Judge,
One trick pony.
he's the guy that, was on the trial docket and then filed some stuff that you were saying we want to get the trial fast enough, so then you set it for
Okay.
hearing about not getting the trial fast enough.
All right, so what do we need to do right now?
Pull them out back there.
Lacey hadn't pulled out the back.
Are we getting him out?
Well,
I thought we just put them on the-
He wants a trial.
Oh, okay.
Let's do that.
Where's this?
Yeah, but he'd like to be heard,
About not getting the trial fast enough. See,
just.
Yeah. God bless him. Okay, who's on? Jessica Wilson, get in line. You're up next, lady. Madam.
Any other words?
the dog.
Yeah. Princess,
I like that one, Judge. That seems to fit better.
it works at home.
The Royal Highness.
It works at my home.
The Royal Highness.
Well, well, I know my lady's earned it, and I'm sure Reagan has more than earned her right to wear the crown.
Oh, see if we're.
Where, Franklin, James Franklin, please, thank you. He's a habitual felon, right? Right? He's a habitual felon?
Sir,
He's a habitual felon?
if it's split that way.
Well, it's 2005, and then thereafter 2021, so works in. That's,
Sounds like it.
and it's like in each case. Well, okay.
Ryan's file, it's underneath those two. Ryan.
Yeah,
Dawn.
get it to you, Marty.
Yes.
He was a very polite man. Come on up. You are James Michael Franklin Jr., correct?
Yes, sir.
And you recognize this man, Mr. Gerbs, your attorney?
Yes.
All right. Okay. You were charged in these two cases. 24 CR 1029 and 1030, aggravated assault with a deadly weapon and also unlawful possession of a firearm by a felon. Aggravated assault is a second-degree felony. You have looks like prior convictions of deadly conduct and aggravated assault out of Jefferson County and Chambers County in 2005. Thereafter, those were final. It looks like you pick up evading arrest or detention with a motor vehicle in this court, and that was a sentencing in 2021. So that second-degree felony, which would carry with it up to 20 years in prison normally, is enhanced to a habitual felon status. You're looking at minimum 25 to life. Do you understand?
Oh, yeah.
24 CR 1030, third-degree felony, unlawful possession of a firearm by a felon. Strangely enough, only has the two prior convictions in 2005. So that third-degree felony can be enhanced to a second-degree felony punishment. I don't know why that wasn't enhanced similarly, but it wasn't. And until it is, you're looking at an enhancement if convicted to a second-degree felony punishment on that one, which is up to 20 years in prison. Mr. Gertz is your attorney, right?
Yes.
All right. We're putting this on the trial docket, right?
Yes, that's what he wants.
That's what you want.
He'd like to file as soon as possible.
Well, you know, nobody should have more cases than trials than me. Nobody's tried more than me in the country.
You told me
So-
that last year.
So, yeah, it's been documented now. Somebody's looked it up. We can only do one at a time. We're gonna slip you in as soon as we can. Trust me, it's It's a work in progress. If at any time you change your mind on this, let me know. But I think you're insistent on it. And that's good. Hey, the Constitution says you have a right to a trial. And it's not, it's meaningless if we can't get it quick. And we're doing it as fast as we can, one after another. The trials today, for example, these are trials that are over 1,000 days old, and we're trying them one after another.
Your Honor,
This is the best I can do. Okay.
if I could speak when you're done, please.
What do you want to say?
Just trial dockets congested with cases like mine that are just completely bogus. If anybody would look at it with some clarity and see what I got going on, they can tell I didn't touch anybody.
That's not for me to decide. I'm the judicial branch.
Before this even came to this, the boilerplate language they used to file paperwork and these lines, these lies and these probable cause affidavits, all that was not looked at.
All right. The executive branch of government brings the case, they bring it to the grand jury indicts. I don't have any say in what they do. I don't have any say in the grand jury. It comes to me, what my job is to, you want a jury trial or to dispose of a case? I'm doing it as fast as I can. And nobody in the country does it like us. So we'll get it to you. I feel your pain on that. I really do. I'm trying it. I'm trying something every day.
Here, I got no bond, y'all, because I'm on parole.
Yeah.
I got a parole hold. I got a family.
You talk to him
That's
about
my
that.
justice supposed to be getting looked at. Nobody taking care of me.
Well, sir,
It's crazy.
Sir,
I didn't.
I've got to get to we've got to get
understand.
everybody together and do it under the rules of evidence and try the case. But the state of Texas, are you standing by your allegations?
Yes, sir.
They've got a different opinion. All right. Set for trial as soon as we can. I promise. So, next, I have some. I got the Wilsons.
Yeah.
Come on up. Ms. Wilson. What's her first name? Is it Jessica Wilson? What were we doing on Eric Norman? Did you say?
Judge, he has 3 new cases that have not been indicted yet and are not in Odyssey, so if we could just have a couple of weeks.
All right, I'll postpone those for 3 weeks, okay?
Thank you, Judge.
Can y'all see where those new cases are? She can't do it in an installment fashion. We've got to package all of that together on Eric Norman. Apparently, there are some new, there's an MTRP, but they've alleged criminal acts, and those acts have not yet been indicted. We need to get that rolling.
Okay. I think if you're right, thumbprint.
So we can
Right there.
get forward together
I need a much.
in all kinds of weather.
Well, the one that is before you right now is a motion of probation,
Mhm.
but the new acts are the allegations, so. I might can understand about maybe wrapping all of them together, we can do something with that.
Just listen, please. I need a file. Wait, I memorized these last night. I can do it. No, she doesn't trust me. 2 cases? What are we gonna do? Both of them?
Yeah.
She's pleading on both?
Yeah.
All right, 25 CR 1255 and 1256 are both called. The state of Texas versus Jessica Roxanne Wilson. That's you, ma'am?
Yes, sir.
Present. With Ms. Manali, your attorney and the state's attorney. Does the defendant waive formal readings of these indictments and the arraignments here? Can we proceed in summary?
Yes, Judge.
These similarly allege the same type of crime. It just looks like there are different complainant victims in each case.
That's correct.
And similarly, these charges state that on or about August 25th, 2025 in Jefferson County, Texas, you committed the 3rd-degree felonies of harassment of a public servant, a firefighter in cause number 1255, and a Beaumont emergency medical technician, EMT person in cause number 1256. And apparently you were spitting on these people when they were trying to help you, it looks like. Which constitutes an assaultive type act. These are 3rd-degree felonies. Each of these carry with it, if convicted, no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed in each case. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty,
Oh, yes, yes, sir.
and let me get to that page. Placed on deferred or unadjudicated probation in each case. Is that right?
Yes, sir.
That's for the parties.
Yes.
Help me out. Y'all got that? Confirm. So you'd be placed on deferred or unadjudicated probation, which can be up to 10 years in the, do you understand? And there's no fine.
That's not fine.
There would be terms and conditions of probation, though, which are normal and customary for this type of offense. And it can be up to 10 years in length. Do you understand? If I follow this agreement, you have no right of appeal of your cases. Do you understand?
Yes, sir, I do.
How do you plead to this? Guilty or not guilty in each case?
Guilty,
Are
sir.
you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1 in each case. Did you sign those documents, understand them, discuss them with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 tendered into evidence in each case without objection, admitted. Among other things, this states you are mentally competent to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by you by your lawyer. All of this is true. It states, so help you God. In each case, is all of that true?
Is all that.
Okay.
Yep. But I need a response.
Oh, yes, yes, sir.
State's Exhibit 1 is made a part of the record in each of these cases without objection, correct?
Yes, Judge.
What occurred here? What caused you to do this?
I was in a car accident and had blood like all over, like my head shook pretty bad. My airbags didn't go off. And I just was completely out of it. I thought they were trying to like make it where I couldn't breathe when they strapped me down and stuff. And he was holding me from my broken nose. That's pretty much all I can say in my defense, but I still committed the act.
Some of these cases you can involve. You can.
Yeah.
That would be.
Okay, where are we on time on that, please? How much? Thank you.
Whatever number, better be there.
Okay, anything else to add?
No, Judge.
If nothing further by either of the parties, I'm going to make the findings that number one, Ms. Wilson here is pleading guilty voluntarily in each of these cases. She's mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But the court is going to instead defer or postpone any finding of guilt on each of these cases. So long as you follow the terms and conditions of probation, the probation officer is going to go over with you. I'm about to sign these. This is going to be for 10 years in each of these cases to run concurrently. You do well. It can be shortened to 1/3, 3 1/3 years. But these are serious charges of assaults on our people who are to help you, our emergency personnel. And if they were spat upon each time they were trying to help people, it wouldn't be long before we wouldn't have anybody working for us. Whether EMT or fire department, we need those people. So they should be appreciated and rewarded, not spat upon. Apparently, there's something about all of this that caused you to act in a delirious fashion. But I think you know better than to assault people who are trying to help you. There will be an anger management program, among other things, to be a condition of probation. Please follow these rules. If you fail, you could be found guilty, sentenced up to 10 years in prison, and that's a long time. Do well. See him and you'll be fine. Okay, thank you.
Thank you, Judge.
Who's next? Please.
Sorry, I'm the only one left.
Well, let's see. Are you ready?
Well, Mr. Wilker saying about calling the bill today, there's no guilty. What's July man building.
Yep, I'm last one.
Did I dismiss that Kimberly Thompson already? Let me see.
Who said it to me?
Okay. Yep. Yep, looks like that's done. And so that's out of here. Eric Norman, we took care of that one.
We reset that this one.
Uh-huh. And I've got Jonathan Brasino. 1, 2, 3 cases.
Two new cases that we two RP, Your Honor. Except for third.
Let me see.
Look, we asked for proceed.
Brasino. All right, bring him out. Brasino, Jonathan Brasino, please. Thank you, Kim. I mean, he's on probation on 2 cases, right?
I thought it was.
Just
Yeah,
one, Judge.
Case and then the two other cases are the 2 new cases that are there.
He has 3 total. One's an MTRP and 2 are new cases.
2 new cases are the basis for the revocation.
Well, this is not. Says he pled guilty on 12/11/23. And this, this is wrong. We gotta fix this one. It shows he pled guilty, but he wasn't indicted until 26. So we got that. That was kind of an odd one.
Judge, I think this is a reused file because they're no longer providing files for us.
Oh, boy. So
So,
we gotta white out stuff.
yeah, I'll just.
Are you
I'll just-
Jonathan Brasino?
Yes, sir.
You've got a case where you were placed on probation on January 13th, 2025 for assault family violence, correct?
Yes, sir.
10 years deferred or unadjudicated probation. In 25 CR 1842, a burglary of a habitation indictment comes along on December of 2025. It alleges on October 7th, 2025, after you had been placed on probation, you committed that offense. And on October 7th, 2025, there's another indictment, violation of bond and protective order. Those burglary is a 2nd-degree felony and the other is a 3rd-degree felony. Then this motion rolls around in December of 25, a motion to revoke probation. And it alleges those 2 new offenses at a location other than your residence after curfew, failing to provide verification of performing community service hours, failing to provide verification of entering and successfully completing the BIF, batterers intervention and prevention program, failing to pay court assessed fees, having contact with the victim. Without permission. Okay, so 7 violations. Do you understand? Yes, okay. So these new cases are a 3rd-degree felony, and then another and a 2nd-degree felony. One's you can be punished up to 10 years in prison, the other up to 20 years in prison. This offense is a 3rd-degree felony where the motion to revoke probation is filed. You can be sentenced up to 10 years in prison if your probation is revoked. What are we doing on
He
this?
said it for a hearing, Your Honor. He's denying the allegation.
All right, we're gonna have motion to revoke. We go on the motion to revoke probation hearings. When can that be done? Yeah, I want it in 3 weeks or less. Can we do that?
We can. It's up to they need to get the witnesses, but
All right.
we'll be.
I'm gonna try to set it for 3 weeks. Okay. Thank you. Next is Shadrick Coleman. Shadrick Coleman.
Thank you.
All righty, man. Are you getting anything done here today, everybody? Or are we just?
I have 4.
The heck?
One of them's not here, and
Come on up. 2 cases are now called, the state of Texas versus Shadrick Coleman. That's you, sir?
Yes, sir.
In 25 CR 1236, you're charged with the state jail felony of fraudulent use or possession of identifying information. Who's that?
He's on the trial, Judge.
What's your name, sir?
Judge, he's Bruce Smith's client, and Mr. Smith is not gonna be here.
What's your name?
Mr. Smith had 2 clients.
3. I know it was called.
Yeah, we were waiting for Bruce Smith to show up. You're Aaron Tyler?
Yes, sir.
And Judge.
That's you.
Mr. Smith said he's not.
I had all talked to him.
And then I have a Harriet Hill.
That's me.
That's you.
He only has 2 clients.
I gave us some things.
That was not said.
Yeah, it wasn't set today. Yours, the only ones from Bruce were Aaron Tyler and Harriet Hill.
Take me for the 23rd.
No, I'm sorry, he's not here and he's ill. So we're gonna have to postpone this and reset it a week, the trial those are 2 on the trial docket, so y'all come on up. You 2, a 3rd one,
It's set on the 26th.
you're Mr. Goodman?
Yeah.
The 26th.
You're not supposed to be here until the
He
20th.
texted me on the 2nd, told me the 23rd.
Oh, no, he said wrong because you're supposed to be here on the 26th,
I
which
live
is
out of town.
Monday, Tuesday, Wednesday, Thursday, right? Yeah, you gotta be here Thursday for some reason. I don't know. But that's when they have you.
You said that you wanted to reset every week until we go.
Yeah, they're gonna be, I'm saying, yeah, reset each week because until Mr. Smith gets here.
Yeah.
Well,
It'll be
and
reset next Monday.
we're gonna just reset y'all on the trial docket each week. We gotta figure it out.
Well, then.
It's the only way. Sorry. That's, he's supposed to, when they're sick, I can't bring them from the hospital.
yeah, so she has to talk.
Okay. On this, okay, we're back on Mr. Holman. You're charged with these state jail felonies. And you got these prior convictions. Which means there were so many of them. So these state jail felonies are punishable as a 2nd-degree felony, correct, in each case? So you were looking at up to 20 years in each of these cases, Mr. Holman. And it's an announcement. What are we doing today?
Yeah, if we get a little more time on this, I've started talking with Just stayed on this, if I get some more time, I think I should be able to resolve it. If I get 2 to 3 weeks.
2 weeks?
Yeah.
I'll do 2. Okay, thanks.
Yeah, he told me so.
Adrian Manning.
I don't think he's in custody, Your Honor. He was in a mental facility, he's now competent, but I don't believe he's.
Is Adrian Manning back there? No. Jadrian Kristen Manning Bob. Jadrian Manning Bob is called 24 CR 2475. No answer in the courtroom. I am asking the bailiff to call into the hall for Jadrian Manning Bob, please. No answer in the courtroom.
Last he was in a facility, he was found to be incompetent. He was sent off, and so he's now competent. We've got the report back, he's competent, but I think he's still in custody with the.
Do you know where he is? We're looking.
There's no response.
There is no response to that name being called into the hallway. No response to the name being called here. The defendant has failed to appear. And
He's
what?
He's not.
Yeah, he's in custody, Your Honor.
Well, where is he in custody?
And wherever he's in for the mental facility, I don't.
Are you sure?
Well, I'm never sure 100%.
Well, I mean,
Yeah.
I'm about to make some findings and decisions. I have to be sure.
Well, I know
Where-
he's called me from the facility and he was sent to the facility.
How do you know he's calling you from the facility?
No ID, but that's about it.
Look, I'm gonna make some
Yes, sir, it does, it looks like he was in the hospital, that he has not been transferred
What's that date?
yet. This is from UT Health, he said he's now competent to stand trial.
What's the date of the letter?
February 16th.
Okay.
He just hasn't made it back to.
Okay.
Jefferson County.
Do I need to make orders to get him sent here, or are they gonna do it automatically?
Yes, sir, they'll send them back
All right.
to us.
I want to review it, though. He ought to be back in 2 weeks.
That's fine.
Okay.
Thank you.
All right. Let's review it in 2
I
weeks.
think I'll be here till Monday, so.
Jesse Medina.
Yes, sir. Need to be brought out.
All right. Jesse Medina, please. On Wilkerson's cases, Mr. Wilkerson is not going to be here. Are his people all in custody?
It's just one person who's in custody.
Ja'Cory, okay, Ja'Cory Green, and he's in custody. All right.
It's just.
Jesse Medina? In 25 CR 1672, you were charged with the state jail felony of unauthorized use of a motor vehicle. If convicted, you face up to 2 years in the state jail. Do you understand?
Yes, sir.
What are we doing today?
Your Honor, if we don't want to talk, I think this might be heading towards a trial, but I want a chance to talk to the state, see if we can avoid that if we can. I think some things we could possibly do. So 2 to 3 weeks, I should be able to knock that out.
He's driving a stolen vehicle. There's.
It was a U-Haul, somebody else had rented it. He did not know it was supposed to be back. He was with the person that was with,
Yeah, I was working, disposing tires for tire shops,
yeah,
and this dog left out, and I just moved the vehicle.
so he didn't. I think it's
And
an.
the dog got behind us.
Yeah, I was like, there's any more.
Well, you've seen this probable cause affidavit? Here's the deal is when the police stopped you, you gave them a fraudulent name, not your real name. You lied to them, which is an indication of deception. So that'll come out in trial and we'll let a jury decide that whether you were unable to remember how to spell your own name and you gave him a false name. That won't play well. But what do you want to do?
About 2 to 3 weeks, I can talk to the state to see if we can.
I'll give you 2 weeks. That's all.
Perfect.
That's all.
Talk to you soon. Thank you.
The court room is in jail. His lawyer is ill, not able to appear. Okay. Back to Jennifer, Cavante Willis. What did we ever do on that? So let's sit down. One,
Judge, I believe you said that for trial.
I was on the jail document.
Oh, I just had reset 4 weeks.
Reset 4 weeks, is that what it was? Okay. All right, what am I missing? Anything else off the trial docket needs to be disposed of?
No.
Well, let's make sure. Harriet Hill,
Judge, that's
that's
Mr. Smith's stuff, it was just reset 1 week.
John. West had a couple, Langston. All right,
Mr. West hasn't said anything about his own house.
Okay, anything else we need to add? Was that done? We're done?
Did we lose Marvin? Because I have one and the family's been here since.
Marvin asked me to set that for a plea in 2 weeks.
Who is it? Who is it?
Jordan Edmonds.
Jordan
Where's Jordan
He's
Edmondson?
in jail.
He's in custody.
No, where's the family?
They're right there.
Y'all come on up, please. Yeah, let me talk to you. Okay, once again, we have what was in the movie, failure to communicate. There was a failure to communicate.
Yes, sir. Because I went and told her, but we were
This was
waiting on
set
it
for
again.
trial. Mr. Lewis was here. And it had to be reset. And nobody, so you can see, there it is. Nobody, I don't have anything. That's why we need to have communication. He's gone. I've got these other cases that are going to be tried first. But we're going to move Jordan Edmondson up because that's 804 days. I just have 1,000-day cases ahead of him that we're trying to get to. But he didn't tell the people, y'all need to know. So it has been reset.
So it's going to be an open plea? Is that what he requested?
He came up to me and he said that something has been worked out. He just needs 2 weeks.
He didn't tell me.
For a plea.
He didn't tell me that.
And
I don't know.
it wasn't numbered,
Call
so
him up real quick.
Because I had made an offer, he countered with an open plea, which is probably going to need a PSI. So there's a big difference here on what the reset date is. If he needs to be involved.
The plea,
Well, who's charged with the crime?
Jordan Edmondson.
Who's that?
Judge, her son is the victim. I did reach out to mom last week and talk to her about what the offer was, and she okayed it with me last week.
Did not, I was supposed to talk to the lawyer this morning, me, you and the lawyer, that's what you told me the first day. You said, oh, I will get with the lawyer, we will meet him with him Monday morning, that's why I came early. But you only talked to him, I never talked to the lawyer, that's what was said.
Ma'am, when I talked to you last week on the phone, you told
I
me.
I said the offer was 25. I say, no, I don't think it's enough. He shot my son in the back for eight times for no reason.
Right.
I say, I would love 8 years on each bullet. You said we can't get it because it's $2.99. I say, okay, well, then you said, would you agree to 30? I'm like, okay,
You're the victim's mother.
yes, sir.
Okay.
And-
Victims and their families have voices to me.
Exactly.
I listen.
Exactly. And so I said, okay, and I thought about it, but I was supposed to meet with the lawyer this morning with her. And I didn't, so we were supposed to agree upon it, but I asked, could he do 40 with no parole? So they say they has no dealings with parole, it's the parole's decision. So because, my son didn't do you nothing, he was just getting in a relationship with your mom. And basically the guy is kin to my first cousins. So it's like a family thing, so it's a lot behind it that I've known, that I investigated, and I got information.
Yes, ma'am.
But everybody say that he sees that, and it wouldn't appear in court, so. And I had, when my son got killed, nobody got in contact with me. I started getting in contact with people, Miss Dobbs, I called Miss Dobbs, I talked to Miss Dobbs, next thing I know, Miss Moore called me.
Yes, ma'am.
Judge, just so the record is clear on my side, I reached out last week and talked to the victim's mom, Miss Dina, about it last week.
This lady.
Yes, ma'am. Yes, sir. And She initially told me about the 64 years, and I explained to her that in this phase, this is a plea bargain, and is there a number under 64 that she would be okay with? And I told her about them coming to me with 25. She said no to 25, but she would be okay to 30.
No, I didn't say that. You said,
Okay.
would you be
Just
okay
if you,
with 30?
if you would, please let me talk because we can't mix it up.
Let me see.
She okayed to 30, and then that's when I relayed the offer to defense counsel of 30. It's not my practice that I tell the victim's parents or anybody that's associated with the victim that we will come and talk to the defense attorney. It's me waiting for them to come back to me to let me know. So this morning when I went to Miss Dina to let her know that I was waiting on the defense attorney to come to me and let me know if they're going to accept it, that's when I got word that she's no longer okay with the 30. So my response was just that I've already relayed that to them because that's what she told me. She was okay with whatever thought she had. Outside of that, I don't know about those.
Okay.
So I had
Well,
already relayed that to them.
then you need to talk to him about the change, and she's entitled to change her mind or she thinks about it. So.
And that's why I was waiting for him to come back and talk to me. So I've been sitting.
All right. I'm gonna reset it 1 week so y'all can try to resolve it if possible. If not, we'll just put it on the trial
That's what I
docket.
want. Trial.
Let a jury decide.
Closure. If I have a trial, I have closure why he really just killed my son.
And Judge, I've tried to explain to her that
Well,
that's not necessarily going to give that answer.
yeah, a lot. If there's a plea, the court gets to the bottom of, for the most part, tries to get to the bottom of the motives and things. And if it's not, I don't have to take the plea. I can, if I'm not satisfied with the response that a defendant is giving and didn't fully admit to the circumstances of the case, then I don't have to accept the deal. And we can say, no, sorry, you wanted that. That's not what you get. You will let a jury decide it.
Okay.
And but it's hard to take care of all the components, but the laws enacted that victims have a voice, and they should, because it's their loss. You've lost something, and you want something for that, justice.
Yes.
And with justice is the forthrightness and information that you don't have, so you can move on with your life,
Exactly.
knowing that why something happened and
Exactly.
not wondering the rest of your life.
Exactly.
And it victimizes you.
Exactly.
And we get to the bottom of it pretty much. I trust her. I've known her. She's a good lawyer. She takes care of the cases very in most fairness, and she's not going to certainly betray victims. We don't want you to get victimized again.
Exactly.
And that's not going to happen on this watch. These lawyers, these prosecutors are very fair, and they're just, but I say it again, we're the 22nd largest county with the 16th highest crime rate in the state. We are all hands on deck, and we're fighting fires 24 hours a day. But that's what we do. We fight the fire because that's what somebody's got to do it. And these are good people who are doing it, but we can only do it one at a time, and that's all I can say. That you can't bring your child back, but we're going to try to get justice for you. And the defendant as well. He's entitled to justice as well, and the way that gets resolved. So those are all parties that we got to put together in every case. So anyway, but rest assured, these are good people, and sometimes mistakes are made, but it's rare. And the mistakes that are made here aren't made maliciously, and everybody can make a mistake.